Good afternoon, sir.
Good afternoon, Your Honors. Justin Parafinzik from Cook, Parafinzik & Wolf on behalf of the plaintiffs. We're here today seeking reversal of the trial court's order granting summary judgment in this matter.
And sir, would you like to save some time for rebuttal?
Yes, Your Honor. 5 minutes, please.
All right, sir.
The issue here, from my perspective, is predominantly a factual inquiry as to the evidence that was presented at the summary judgment hearing, which is our position that there was a issue of material fact, and the defense of loss of consciousness should not have deprived my clients their right to a jury trial in this matter. So I'd like to go through the prongs and look at the defendant's burden of proof on these issues and point out some details in the testimony that I'm not sure are specifically highlighted in the brief.
But before we get to that, would you agree, at least under a legal premise, that if, in fact, a driver would lose consciousness, that basically there will really be no negligence in this case?
Yes, Your Honor, that's precisely what the statute is for.
All right.
And it's, but I would say with the caveat that driver cannot have knowledge of an existing condition that they had that would cause them to lose consciousness. For instance, someone with a history of strokes or seizures or other issues, the statute is also predominantly a protection statute to protect other drivers.
Correct.
But it certainly absolves someone of negligence because you cannot satisfy.
It's outside of your control, and negligence is,
Right.
That means you had to do an act that would put things in motion. In a nutshell, that's what it is.
Precisely, Your Honor.
Is there really any dispute here about the loss of consciousness or capacity prong of the test? I mean, I understand that there's a debate about foreseeability, but is there really any question that Miss Barton lost capacity?
Yes, Your Honor. It's our position that there is, and that's why I wanted to address this oral argument and to point out, predominantly hone in on Dr. Montoya's testimony, but I have several other arguments about the other witnesses at the accident. Specifically, if we look at Dr. Montoya, I don't believe that the brief gets it out as precisely as I could maybe say it, but on page 7 of our brief, for instance, we reference the critical portions of her testimony, which are her opinions. Now, third line down, she testifies that the stroke, if you will, most likely occurred while she was driving. Okay, and the important part here.
If you go back, I mean, the question was, what is your opinion to a reasonable degree of medical certainty regarding when the stroke occurred? And
Right.
Dr. Montoya responded, it most likely occurred while she was driving.
Right.
Okay.
And again, that's not conclusive. That's the boilerplate language that you use with any expert, but there are still ways to attack the credibility of an expert, which she boxes herself in with the time frame when she says occurred while she was driving.
Well, let me ask you this, because we can't decide this in a vacuum. I think the undisputed facts are that this lady goes through an intersection, clips or impacts a car in some way, and then the car then drifts into private property and into a private parking lot. Is that true? Am I on point?
Your Honor, that's a basic recitation of the facts.
Okay. And the testimony from one witness is she's going slow enough that this female can run 100 yards, catch up to the car, get in the car, and put her foot on the brake, and then have a conversation with her.
Pick up the keys.
Yes, that's all correct, Your Honor. And
so what about those undisputed facts demonstrate that she didn't have a stroke before she hit your client's motorcycle?
Well, it goes back to the inconsistencies in Dr. Montoya's testimony, but I can present, a counter argument to that factual scenario that could be presented to a jury, which is part of.
Well, give me triable issues. Don't give me speculation, because you asked Dr. Montoya a lot of questions that are possibilities, and you and I know you tried enough cases you're going to get an objection speculation, and that's not admissible. You know that.
Right.
And this is medically intensive testimony.
Mm-hmm.
So possibilities, you know, even though the summary judgment standard says the slightest doubt, it has to be a genuine issue of material fact, which means it's a triable, colorable issue. So give me something that's admissible that disputes this.
Well, if we look to Dr. Montoya's testimony, as far as an admissibility standpoint, there's no question that her testimony is going to come in. So the credibility of her testimony is issue, and there's an issue of material fact with it, which is the timing of the stroke, if she even had a stroke.
But here's the point to follow up, and that's why I couched it is the standard for these type of cases is within a reasonable degree of medical, not possibility. And the doctor testified that yes, in my opinion, this is what it occurred while she was driving. I think later on, even the doctor indicated there's no way that the way the mechanics of the stroke that she would have incurred a stroke prior, because there's no way she would get in her car. The way that the mechanics of the stroke should be totally immobilized. And so what you have cut and pasted is portions of it when you have, can you be absolutely certain? Is it possible? Well, that's really not the standard to create an issue fact.
If I may, just I would slightly disagree with Your Honor on that aspect. Again, we're only focused on one answer to one question that she made. She contradicts herself blatantly. If you look at page 8 of our motion, where her response to the question and answer is, what is your opinion with respect to Ms. Barton's capacity to drive? This answer gives at least 3 different possibilities of what could have happened. She says, I mean, obviously, once you have the stroke, you are not able to drive. Well, if she's saying that, then that contradicts that she says the stroke most likely occurred while she was driving.
I think you're reading too much into it, I think.
Well, there's more to it than that.
Well, let me ask this question. All right, You've got kind of the circumstances of this accident. In other words, the other side comes in and says, listen, you've got Dr. Montoya who testifies that it was likely a stroke, that it likely happened while she was driving. And you've got the circumstances under which it happened that paint a picture of something happening while this person was driving. She glides through an intersection, goes incredibly slowly into a parking lot, and has to be stopped by a third party. The witnesses are uniform, and their characterization of it sure looked like there was something wrong with this person. What's the theory you're going to present to the jury? What are you going to tell the jury happened?
Your Honor, I can skip right to that. I think there are 4 certainly feasible trial theories. Number 1 is that no stroke occurred. She was confused, ran through the red light, got trapped in the middle of a 6-lane intersection, panicked, didn't know how to react. This is the thing that happens.
Well, let me ask you a question, because you have to concede whether or not a stroke occurred requires medical testimony. And I don't see any medical testimony in this record that it was anything other than a stroke. And Judge Kazam talked about the standard. It's not certainty, it's probability and the most likely. She said that this lady had a stroke, and I read the transcript of the motion for summary judgment hearing, and I don't know if you tried the case below, but the plaintiff's attorney below said, Judge, really the issue is whether the stroke occurred before the impact. So it seems to me they conceded that there was a stroke, because I don't see any other evidence in this record that it was anything other than a stroke. Now, were there contributory factors? Maybe, maybe not, but I don't see any evidence where this was anything other than a stroke.
Well, Your Honor, the thing is that her symptomatology and the other medical records, and keep in mind that Dr. Montoya never did an evaluation of the decedent herself. She only reviewed some medical records and testing afterwards. But, you know, I go back to her answer where she gives all these possibilities. And she says, I mean, did she realize she had a stroke first? Second, did it happen when she just got into the car and she drove anyway? Well, she had already testified that she couldn't drive the car if the stroke happened. So she herself is questioning that in her own testimony.
But she testified also that the stroke caused a loss of vision in her left eye, and that the stroke would have caused a loss of control on the left side of her body, which is consistent with the complaints that she had once EMS arrived.
Right.
So you're implying that there were other treating physicians who could have been deposed and given contradictory opinions, but they're not in the record here.
And even confined to the record, Your Honor, it doesn't conclusively prove that she has a stroke. She had 2 symptoms consistent with a stroke. And if you go to the witnesses, they're also uniform, that it's undisputed that she had both hands on the wheel the entire time. Her eyes were wide open. They were not closed. She was not unconscious. And the first person that she talked to, the person thought that she was a diabetic. She specifically said, "No, I'm not diabetic." She had a conversation with the first witness. And after that, she said, "You know, you hit these people on the motorcycle and you went through 6 lanes of traffic." And she said, "Yes, they were in my way. I hit them." You know, evaluated at the hospital later on, again, she was virtually asymptomatic of any heart attack. And then further on, after there was some looking back and testing done, it became clear that she had actually had a stroke prior to this, which you know, goes to another argument, which is this would have been foreseeable had she treated with a physician for the prior 10 years.
Is there any summary judgment evidence that she was aware that she had a stroke?
No, there wasn't.
Or that her son was?
No, the indication would be that the conversations with her son were loss of memory and inability to put sentences together coherently when they had conversations. Should have alerted her or her son that she needed.
She had lost words and was losing memory. I don't think there was testimony that she had an inability to put sentences together, was there?
Yeah, it's a phrase. I'm phrasing it that way, but in the brief it was difficulty. I forget what his specific testimony was, but it was of that nature, that some of her sentences she struggled to find the words to.
77 years old, Alzheimer's, it could be a number of things, but not to say, oh, that put her on notice that she must have had a stroke.
No, that's not our argument. Our argument is to put her on notice that she needed to see a physician, which it goes back to the justification for the statute, which is to protect other drivers. She needed to see a physician to have these issues at least evaluated, and from a reasonable person's standpoint, at 77, shouldn't someone see a physician and be aware that they are able to drive without a pre-existing medical condition that was in fact there?
I suppose the argument you make is inference on an inference. If you infer she had that, therefore it would have been another inference. She would have gone to the doctor, and therefore a further inference that doctor would have concluded that she must have had a stroke, which then brings another inference that she was unnoticed, she shouldn't have been driving. We're dealing with a summary judgment standard based on the record before the court. And the bottom line is there's really no contrary affidavit by another medical expert or anything to counteract Dr. Montoya's testimony. Would you agree with that?
Your Honor, unfortunately I can't. I simply disagree with that. Dr. Montoya was cross-examined. There's an issue of material fact with her testimony and with her credibility. She contradicts herself several times in her testimony. And in my view, as a trial lawyer, and I think there are several theories of liability this case could be tried on in the trial court. I have at least 4 ready to present when Your Honors would like to hear them. But her testimony completely falls apart. On page 3 of the brief, where she's asked, I'm sorry, not page 3. On page 8 of the brief, when she's asked about Ms. Barton's capacity to drive, her answer gives far more possibilities than just the stroke and when it happened and the timing of the stroke, and all these are important. And I think it's extremely important that she says she would not, she gives the possibility that she could have had the stroke when she just got into the car. Well, that's not really feasible, because if she had the stroke when she got right when she got into the car, according to Dr. Montoya, she wouldn't have been able to drive, which means this accident never happens.
All right, and let me, oh, do you need to ask? Because I was about to tell you you're going into your rebuttal time.
No, I'd like to.
Under what evidentiary rule is a question to an expert witness the possibility of anything admissible?
I mean,
under what evidentiary rule is that admissible? It's pure rank speculation. You never asked her within a reasonable degree of medical probability. You never asked her, should she have seen a primary care physician? You didn't ask her that. You never posed the fact that this witness, DeJude, got into the car and inquired of her, and she gave a certain answer. You never asked why she was able to give that answer. So what you're doing is you're trying to compare and contrast a medical expert's testimony with your speculation, and then you're asking a jury to reconcile that when your possibilities require expert testimony.
Your Honor, I disagree that it's speculation at all, and frankly, I think that it is admissible under 702. There's wide latitude to cross-examine an expert witness on what possible hypotheticals could or could not occur and possibilities.
All right, let me save you the rest of the time for rebuttal. Thank you, sir.
Good afternoon, Your Honors. May it please the court. My name is Margaret Good, and I represent the appellee, Alan Lund Barton, as personal representative for the estate of LCB Barton. Pat Crowell is with me here on behalf of the appellee. We request the court affirm Judge Foster's grant of summary judgment on the defense of sudden and unexpected loss of capacity. At summary judgment, we established all of the elements of the defense. An appellant has not come forward with any evidence that shows that there is a genuine issue of material fact here. This court's opinion in Markham versus Hayward lays out the elements. The defendant must prove that she lost the capacity, that the loss of the capacity occurred before the accident, that it was sudden, and that it was neither foreseen nor foreseeable. I would like to briefly address the point of foreseeability. In Dr. Montoya's testimony on the record on page 322, she testifies, a stroke per definition is something that happens suddenly. That's the definition of a stroke. So it's not something like just having some pain or something like that for a few days, and then you have that, and then you start having weakness in one arm, and then weakness in the arms. A stroke is not something that can be foreseen by definition. There are several opinions that have been cited in our brief discussing the standard of foreseeability. You don't need to go through all that.
We've all read your brief, and we're familiar with that standard.
Then in that case, if there are no questions from the bench, I will request that this court affirm Judge Foster's grant of summary judgment.
All right, any questions? Maybe? All right, thank you, ma'am.
Thank you.
You have just 2 minutes for your...
Thank you, Your Honor. Briefly, again, I just want to jump back to when we're talking about a trial in this matter. I addressed one issue, which is that she could have gone onto the intersection, not had a stroke, and been very confused, and her best exit was to pull into the shopping center and panicked and got in there eventually. The other option under a trial theory is that she suffered a minor stroke and that it did not render her incapacitated. She was still able to drive her vehicle. Both hands were on the vehicle. The witnesses testified that she was completely coherent and could speak to them and tell them, in fact, that she was not diabetic, as they speculated. As to the witnesses, I would suggest that the speculation in this case is rank is by the witnesses. And it was all disproven by the driver in this case when she said to them specifically, I am not a diabetic, there's nothing wrong with me, and I know what happened, and I know that I hit these people that were in my way. The other option is that she did suffer a stroke, and it simply did not diminish her capacity at all, a full-on stroke. Again, for the same arguments that I've already stated. And finally, she did, and we discussed this earlier, but I'll just put it out there for the record.
There's no need, I mean, unless it's pure rebuttal to her argument, is there anything else that you wish to bring it to our attention, sir?
Just the final point that, you know, again, that she did possibly suffer a stroke, but that there's negligence in the fact that she didn't treat with any physicians for 10 years to detect that prior to driving a vehicle.
All right. Thank you, sir.
Thank you.
Thank you both. All right, this will conclude the docket today. We stand adjourned.